Uh, Mr. Lee, you may begin if you wish.
Thank you, Your Honor. As you said, my name is Brian Lee. I represent Lesbian Matut in this appeal. I'd like to reserve 3 minutes of my time for rebuttal, if I could.
Very well.
So this case, as the court knows, comes to it from a summary judgment that was entered by the trial court, where it found that Ms. Matut could not establish constructive notice of the water that was on the floor at Publix. And we believe that that was in error for a couple of reasons. The case law that we've cited and the federal law that I look to, particularly the Garcia case, talks about where what a court looks at when it sees whether there's constructive notice. There is it starts right from the beginning, where if there's a lack of evidence indicating that there was even a substance there. We don't have that in this case. We know there was. Publix agrees that there was. They said that in their request for admittance that there was. They agree that one of their people or the employees cleaned up the mess right afterwards, and so we know that it was there. The the other part of this talks about how the substance ended up on the floor. Well, we the camera angles, and I will concede, and I think everyone would concede that they're not great because it does we don't have a camera angle that shows the actual floral refrigeration units where this happened, but you can see at least from the side of it when you're looking at it, the slip and fall that occurred. Miss Matute said she fell, and we can also see at least the customer 19 minutes before opening up the refrigerator door and taking out flowers. You can see the customer with flowers later on in some of the other cameras too. And so we have at least circumstantial evidence as to how a substance ended up on the floor. And the trial court, frankly, put that into effect too. We also have evidence of well, one of the things that you can look at is if there is evidence of the business owners, in this case Publix's, neglect in inspecting its premises. We have a lot of evidence we presented both to the trial court and certainly to this court regarding all of Publix's policies and procedures regarding this particular area. This particular area was specifically called out in some of Publix's procedures as being an area where water would be on the floor. They told their associates to look for it, and it's along with other things like flower petals and things of that sort. But we also have evidence that there is nothing that Publix had as far as any inspections that were done of that floor. We do see in multiple instances Publix associates walking past the area, but so there certainly is evidence there that they were there to see it, but none of them did anything. Frankly, most of it just kind of went right by. And so we've got multiple in that, even in that 19-minute time frame, multiple employees that could have seen the water if they were looking at it. And so the last thing that we have, and this is one of the factors too under the Garcia, is okay, well, what is the subject? What's the condition of it upon discovery? Well, we do know, and I don't think it's disputed, that it was a clear substance. It was water. There was no testimony. Miss Matute didn't say that there was, track marks and things of that sort. She did call it a puddle of water. There is some obviously discrepancy on that between the parties. Publix wants to say that it was a couple drops of water. We want to say it's a puddle according to her testimony, but evidently there was water there. And so when we look at this case, that's the facts that we have in the case. And the trial court, through its order, said, well, because there was this liquid on the floor that was there for less than 20 minutes, that in and of itself means that constructive notice cannot be proven by Miss Matute.
Go
We've
back a
presented.
moment if
Yes, Your
you
Honor.
would, Mr. Lee.
Sir.
If we accept your statement that there were employees who were in the area,
Mhm.
it strikes me as it's hard to get the distances between where these employees may be and refrigerated unit. Is that fair?
Sure. I mean, we don't we know. The angle that we've mostly used is sort of back area angle where
Yeah,
you could see like a refrigeration unit there in the sort of middle of it. And you see kind of employees walking through that area. Um, we don't know whether, but we also see, I think, in one of the videos, and again, it's tough to see. I'll concede that, but we do see Miss Matut sort of stumble back into the frame, right, of the video, and so we know that the area where she slipped is at the very least just off of the camera angle that we're talking about. And so when we're looking at employees that are kind of coming through that area, I would I would say that the video has a fair at least inference that we're not talking about a situation where they're 20 feet away, frankly even 10 feet away. We're talking about that these employees, or at least some of the employees, are getting within feet. Whether that's 5 feet, whether that's 6 feet, I don't know. But they're at least within the area, and there's nothing within the any of the Florida law that says that, well, an employee has to be within this amount of feet, or all it says, and this I'm looking really at the Marcotti case, which is a Winn-Dixie case out of the Fifth, and what they say is that it's not so much that employee has to know, meaning that we don't have to prove as a plaintiff that, yeah, absolutely, that employee would have absolutely saw it from the angle that they were doing it. What we have to prove is that that's kind of actual knowledge, right? What we have to prove is that public should have known, and what that means is that they had a legal duty to use reasonable care to look for and to discover reasonably foreseeable, but not actually known dangerous conditions. That's from the Marcotti case, right? So the Florida law builds in this concept that, look, you're not going to, if we were going to mandate that a plaintiff has to show that an employee would have absolutely seen that when they went by, it's never going to happen, frankly, because I don't know many employees or corporate representatives that are going to say, "Oh yeah, I absolutely would have saw that." Right. What we have to show is that not only they have a duty to do reasonable inspections, they did. We proved that in this case, but that it's reasonably foreseeable that they would have seen it, right? And it's not actually known to them. So we've seen, and part of that deals with whether it was there for a length of time, whether an inspection could have revealed it, or whether they actually do inspections. Is there reasonable inspections that they do? And in this case, we've got evidence that shows not just that there wasn't reasonable inspections, we have evidence to show there wasn't any inspections of this area. And we also have evidence to show
But let me
that
ask you a
Publix
question
knew
about
that this
inspection.
area in this, oh, I'm
Let
sorry,
me
go ahead,
ask you a
Judge.
question about
I apologize.
inspection. Yeah, it's
Yeah,
okay. And I don't mean to interrupt you either, but
no, you're
uh,
right.
uh, are they required to do inspections?
Yes,
By whom?
they are. Well, they're required under the law to do inspections.
Tell me where in the law it says that.
There's multiple cases that they talk about. Let me look at the inspection. Well, there's cases where they talk about where inspections are part of the claim, the negligence claim that a plaintiff is bringing. Marcotti is specifically talking about that. It-
So,
it-
so these cases basically have a requirement that someone in these businesses must do regular inspections.
they must do what they call, Marcotti calls it, a reasonably diligent search or inspection. That's the wording that Marcotti uses. That wording is
Is
sort
there
of
anything
used.
that triggers this inspection? Is there, I mean, in other words, they just have to have people all day checking these floors?
No, I don't think it says all day, Judge. I think, I mean, again, the language that they use in Marcotti and other cases say a reasonably diligent, right? So I guess there is some give and take as to what is reasonably diligent, but I think the reason why the courts have made that not a specific, meaning that you got to do, 5 inspections within 5 hours, is because they give room for a jury to be able to determine whether that was reasonable. Right. And so it's not a situation where a judge, and I haven't seen any cases where a judge has been able to say, as a matter of law, that, well, because Publix only did one inspection in an hour, I'm finding that that was reasonable.
Well,
I,
that's kind of my point. And in this case, we have a 19-minute window,
right.
right? And I don't think anybody, I think it's undisputed, they did not inspect during that 19-minute window.
Mhm.
And
Yes.
it's clear
So-
that some Publix employees came sort of to that area. It's not clear to me that they actually traversed that area, but there were a couple of Publix employees that came near it, but didn't notice it, didn't look, didn't pay attention, didn't do anything. So I guess, what I'm scratching my head with is,
Mhm.
there's a 19-minute window. There's no precise regimen of inspections that has to occur. So what do we have it to show that their failure to inspect in this 19-minute window was not reasonable?
Sure. So there are cases that I've cited to in my initial brief, which there are courts that have said that anything that they found that at least 15 to 20 minutes to be a sufficient time for a defendant to be charged. This is the wording from it, to be charged with knowledge of the condition and a reasonable time in which to correct it. Right. That's the Winn-Dixie versus Williams case out of the third, the Lynch versus Target out of the fourth. There are other cases that I've cited too as well in the federal realm that talk about that. The federal courts, particularly the Bray case out of the federal court, even talks about it in the sense of kind of against sort of what Florida says is that there really isn't a time frame. And the Bray case says, Judge Hinkle in that case said that the statute doesn't really establish a grace period. And whereas, Florida courts sort of say that 15 to 20, some others say different minutes. But what Judge Hinkle in that case, I think, goes really to what the question is that he says that a jury could find that if the liquid was on the floor long enough for a passing employee to see it, then the liquid was long enough for the employee to know it was there. And so that's really what we're dealing with when we're talking about whether
But don't
it
those
was
cases also involve a situation where it is no longer clear, a clear liquid, there's signs that somebody may have schlepped through the water or what have you?
there are cases, yeah, you're correct. I mean, there are cases where there's scuffs and footprints. There's other cases where it's not an actual liquid, but it's actually like an object, like it's a grape, on the floor or part of a grape. But there's nothing in Florida law or federal law that I can see that makes that a difference. Because
Well,
and, and I
it's an indicia of how long it has been there.
Sure.
And
Yes,
somebody should have
it certainly
noticed.
can be.
Yeah.
Yes. I think and the way that I read the Florida law on that is that if you had something that was there on the floor and you had nothing else to show you potentially how long that could be there, right? You don't know. Then you can look at these things, right? You can look at how big it is. You can look at where it's come from. You can look at, scuff marks and things like you talked about. What we have in this case, we believe that we've got sufficient evidence to show, or at least to have a reasonable inference, that when that customer took those flowers out of there, that's when that liquid got on the floor. There's nothing else in the video for the time before and after this 19 minutes that would have caused it, right? And so at the very least, even if it was there longer, that's even better for us, right? So at the very least, it was on the floor for 19 minutes. We know it was on the floor because Publix agreed that there was water on the floor. And so that 19-minute span means that we don't have to have that evidence of track marks and things of that sort because we know that a reasonable inference from the evidence, or frankly, the evidence, is that it was on the floor for 19 minutes. And so when we then go to cases in Florida, even the Florida cases say 15 to 20 minutes, that's long enough for you to have done an inspection and to have found it and implicitly to clean it up. We know that did not happen. And even if the argument is that, well, the employees were in this area versus this area, I still think that does not matter under Florida law because that time frame was sufficient for an employee to discover it. Whether or not someone came through there doesn't really matter in that instance. But we do know that some people did, if that makes sense. So For for multiple reasons, Judge, we think that the evidence was there for us, for the plaintiff. And again, summary judgment is not for us to prove beyond a shadow of a doubt. Um, Summary judgment, it can only be entered if the plaintiff cannot present sufficient evidence that a jury could then use to determine that there was constructive notice on the part of Publix. So we think that we presented enough evidence to do that, Judge. And because that was the reason that the trial court said that summary judgment was warranted, we think that that was an error. If there's no more questions, I'll just reserve the rest of my time for rebuttal, Your Honor.
Okay, we'll give you your 3 minutes on rebuttal, okay?
Thank you.
Okay, Mr. Wolf, you are up.
Thank you. Good morning, Your Honors. May it please the court. I'm Diane DeWolf for the Appellant Public Supermarkets. Your Honor, summary judgment is common and appropriate in slip and fall cases like this one, where there are no genuine issues of material fact and Publix can prove that it's entitled to judgment as a matter of law. So let's take the first part of that. We don't have any disputed issues of material fact. Contrary to what Mr. Lee has said, Publix does not dispute that whether it was a few drops of water or a big puddle of water. Plaintiff disputes that herself. She says in her deposition testimony, it was huge. It was a big puddle of water, like a liter of water poured on the ground. Now, imagine that on a hard floor. It's a whole liter of water. It's huge. It's still clear. There's no footprints. There's no track marks. There's no cart tracks. There's nothing like that.
What about your duty to inspect?
Well, that's the second part.
Well, it may be the second part, but it's the part I really care about.
Right.
The duty to inspect, and coupled with what part of the store are we talking about? We're talking about in the floral section where people are taking flowers out and waters on flowers. So is there a heightened duty to inspect? And normally, and it looks like in this case also, your floral section is near the entry. So not only is it near the entry, it's got people taking flowers in and out of water. So is there a heightened level that Publix has to inspect? A, because it's near the entrance, and B, because water's coming and going from these flowers. And so it's more reasonable to expect you're going to have water on the floor here. That's my question.
Right.
And I want to add one fact to that. And Publix knows it because they put those bags there for people that are buying flowers so you don't drip water.
Correct. And the bags, if you look at the video, you'll see they're near the cut flowers that aren't in the case. So everybody knows that there's always cut flowers on the top shelf of a floral case that come out and drip water everywhere. But let's talk about Garcia, because in the reply brief, they accused us of not trying to distinguish Garcia. And Garcia is the case that talks about these inspections, right? And here's what happened in Garcia. The plaintiff was in a high traffic area. She was moving from the store into the garden center and she slipped and fell in water. That's a high traffic area. So the Walmart employees in that case said this. They said, we have 1 to 3 people who do nothing all day but sweep the floors. We have a policy that says we are supposed to look at these high traffic areas, these active alleys, every 5 minutes. And by the way, I did that. I looked at it every 5 minutes. And so then they turn on the video and they see for over an hour, nobody looked at that area. There was not one Walmart employee that went in there and looked at that area. There was no one who swept. There was no one who did anything. So they said, you violated your internal policy 12 times during that hour because you're supposed to do it every 5 minutes. You didn't do it at all. And they said, wait. Look at this other case. Let's look at King v. Walmart, right? And in King, there was no inspection for 90 minutes. And the court said, no, the policy in King was not to inspect every 5 minutes. The policy in King was to sweep the floor several times a day. And I would point you to Publix internal inspection policies, which are in the record at pages 1207 through 1209. And Publix policies are very, very similar to the policies that were in place in Walmart v. King. Publix is instructed to do these things before the store opens and then throughout the day. Okay, there's no set time that they're supposed to do anything. Now, Publix, right, and plaintiff is also relying on Winn-Dixie v. Marcotti, which is the reasonable person standard case, right? Marcotti says you are not responsible for every square foot of floor every minute of every day. You know, public supermarkets, what? They're open 15, 16 hours a day. They're 50,000 square feet. You can't expect.
That raises a question for me. The video suggests that there are at least 3 Publix employees who are close to that area. It's hard to tell how close, but is it unreasonable to infer that one or more of them should have become aware?
Well, again, in all these cases where they say you should have been aware, we have something, we have an employee doing not what they're supposed to be doing, an employee violating a policy, violating a store policy, and we have something that's not clear. I mean, again, I have to go back to, you know, plaintiff saying, 1, it's a liter full of water, and then 2, it came from flower stems, which I mean, a court is expected to see the facts of the light most favorable to the plaintiff, but it's not required to accept facts that are utterly and completely implausible, right? So we cannot, I can't wrap my head around the fact that a liter of water could drop off the stems of one bunch of flowers that were grabbed out of a bucket of water on the top shelf of a closed refrigerated cabinet. But in any case, we don't have any employees violating policy here. So this happened at 3:29. We have an employee supposedly who came by and restocked one of the flower displays right outside the floral department. Didn't walk around to the other side where she originally slipped on drops or a liter of water, depending on which one you believe. Then we have 6 minutes later, we have an employee coming and stalking and inspecting the bread and wine display, right? Which is also not in that same area. We know that no one alerted Publix to any water being on the floor. We have no accusation that Publix caused the water to be on the floor. We have a few drops of very clear water that we have really have no reason to believe that Publix knew it was there. They say, oh, well, it was visible from the customer service counter. Well, you know, I don't know how far away that is, but it looks like it's kind of far. It's not really plausible to believe that the customer service counter could see a few drops of water, 20, 30 feet away on the floor behind,
Yeah, well, my
floral display.
Publix might be configured much differently than your Publix.
Yeah,
Right?
I think they might all be configured a little bit differently. I'm just talking about the what I could see on the video, because the video and the pictures that plaintiffs put into their brief is the camera that's behind the customer service counter,
Right.
looking that way into the floral department. So, if we had, I'm sorry, did you have? No. If we had, employees not doing what they were supposed to be doing, this isn't Markowitz, right? This isn't 3 employees who were supposed to be watching these elderly people carry their food from the dining hall into their rooms. They were sitting around chatting and a grape was on the floor. They weren't doing what they were supposed to be doing. This isn't Williams-Sonoma, where they had a written policy that if something is spilled on the floor, you stand there. You stand there and you don't leave until it's cleaned up. They didn't do that, right? They went into the back room to get paper towels and someone slipped in it and fell. This isn't Garcia, where they're supposed to inspect every 5 minutes and an hour goes by and not one person is on camera inspecting anything and somebody fell. That's violating their own policy. This is Jennings, same thing. A kid was supposed to sweep at 4 o'clock. He didn't sleep at 4 o'clock and somebody slipped and fell. Here, Publix policy is just like that in Walmart versus King. We're supposed to do things throughout the day, several times a day. We can't be responsible for checking everything every 5 minutes, every 10 minutes, even every 19 minutes. There is no way to be on every spot of that floor. And again, I mean, Publix isn't disputing the size of the water. We know a couple of things. We know that plaintiff changed her story and said it came from water stem. So that, puts in your head that it's much smaller, right? We know that the corporate representative said, I saw them clean it up with a paper towel under their foot. That hardly seems like a liter of water, right? So, regardless, the trial court took everything plaintiff said is true and said, under the facts of this case, you cannot prove constructive notice as a matter of law. I don't think you need to go to tipsy coachman here. We did mention it in our brief, because I guess because of the difference, like if it was a large liter of water, then it obviously didn't come from flower stems. Then we're in Delgado v. Laundromax. We're in Ken's v. Miami-Dade County. We're in McCarthy v. Broward College, right? We're in a big pile of water. It's clear, no footprints, no track marks. Nobody walked through it. Nobody knows how long it was there, because that wouldn't have been there for 19 minutes because that wouldn't have come from flower stems. So we have no idea where it came from. Then that's easy summary judgment. So that's where we mentioned that at the end of our brief, and you can do that because the facts are here and the court did see them, because you have the video and you have plaintiff's deposition testimony where that's what she said. So, Your Honors, if you don't have any more questions, if any case.
Well,
Oh,
I
you
guess,
did.
I feel like all of these statements that you're pointing to, I mean, this boils down to, did Publix behave reasonably? And I'm struggling to understand why, given all of the things you've articulated, that really isn't a classic jury question. Because doesn't this case just boil down to whether they acted reasonably under the circumstances?
Well, I think the argument is do they have constructive notice? One of the ways that you prove that they have constructive notice is if they've deviated from their own policies, and they didn't do that here. They're saying, no, they didn't inspect.
Can't you also establish constructive notice by showing that they didn't conduct reasonable inspections?
Well, I think that would be more like the Greenleaf case. An unreasonable inspection would be, you didn't do the inspection the night before like you're supposed to, and nobody walked outside all day long. Here we've got a 19-minute window, right? We have three.
Yeah, but we've got this flower section, and couldn't a reasonable juror conclude, given Publix knowledge that this area is prone to having water spills, which they try to prevent by supplying those bags, that this area, if you're over there, you're stocking bread, you're doing whatever, take a look. If you pass through this area, take a look. That would be reasonable to ask Publix to do that. Or maybe, some other part of the store that wouldn't be reasonable, but in this area, maybe that is reasonable. Couldn't a jury conclude that? You're saying no reasonable juror could find that this area should receive more attention?
Well, I think, Your Honor, you're in danger perhaps of creating a bright line rule that 19 minutes is enough time, that anything longer than 19 minutes is a reason.
I didn't say a number of minutes. I said you have employees, when they're in that area, take a look. You're over there stocking bread, turn around, take a look. Check out the floral section if you're in the vicinity.
I don't think that there's any evidence that they didn't really look. Employees aren't required to walk around with their head down looking at the floor all the time. And we're talking about a couple of drops of clear liquid that somebody eventually wiped up with a paper towel under their foot. This is a very small area. So, Publix employees are constantly looking. They're constantly checking the floors, but they're not walking down, right? If they're walking down with their head down, then they're in danger of walking into people, of causing more danger, right? And I think in this particular case, we have 3 employees who are doing exactly what they were supposed to be doing, stalking, looking around, doing their jobs. There is nothing here that says, Publix doesn't have a policy that says, when you go over and you stock one of these floral displays, or when you stock this bread and wine display, that you have to take a loop around the floral department.
I don't think I suggested that they had a written policy, but I'm talking about what's reasonable under the circumstances and what a jury could, a reasonable juror could conclude.
Well, Your Honor, again, we've cited, we talked about Garcia, and Garcia distinguishes that case from Williams, and Williams had the same exact, I'm sorry, not Williams, King. Walmart v. King v. Walmart. They distinguish that, and that's exactly what we have here. The King v. Walmart case, they had a policy that they are supposed to sweep throughout the day. That was their policy. And there was evidence that no one had swept in 90 minutes. They didn't find that unreasonable. It's not unreasonable. You can't, and Marcotti says this, you cannot be over every place. And that was a high traffic area in King as well. And you can't expect every single square foot of a 50,000 square foot store to be inspected, every 5 minutes, 10 minutes, not even 19
Well,
minutes.
I don't think I suggested every single square foot. I think I framed my question around this particular area that Publix has recognized could be problematic. Just like stores that put plastic bags at the entry for people to slip their umbrellas into, so their umbrellas don't trap water throughout the store. That's an acknowledgement, and we know this could be an issue. We want to try to prevent this kind of event from occurring by, trying to limit the amount of water that ends up on the floor.
And there were, you can see it in the video, there's mats, there's green bags, there's employees that are there stocking shelves. There's very difficult to see a few drops of clear liquid on the floor. And if it was a liter of liquid, as plaintiff initially claimed, and you can also watch the video and see that 14 people walked through. I counted 14, there may be more. In that 19 minutes, 14 customers walk exactly through where plaintiff walks. So if there was a liter, there would have been something there. There's not. Obviously, these drops were so small that those 14 people managed not to step on them, or else they weren't there for 19 minutes. But in any event, no, I don't think a reasonable juror could find that this inspection was not reasonable under these circumstances. I think you'd be in danger of creating a bright line rule. And that is, the King case tells us that an inspection wasn't done for 90 minutes and it wasn't swept for 90 minutes, and that's not unreasonable. Your Honors, I think if any case is appropriate for summary judgment, it's this one. This is a simple case of a few clear drops of water on the floor, and someone fell. And that's just not enough to survive summary judgment. So we ask that you affirm.
Okay, thank you, Mr. Wall. Mr. Lee, we'll give you your 3 minutes.
Yes, Your Honor. Thank you. Hopefully I won't use them, but I'll try not to at least. There's a lot of things that were said there that frankly aren't evidence. There is no evidence that whether it's drops, whether it's a puddle, or that was not able to be seen by anyone. There's no evidence of that. Publix hasn't presented evidence. There is none. There is no evidence that their employees didn't see it. There was not an employee that came in and their testimony is that I went through this area and I saw nothing. There is no evidence about that. What there is evidence of is that Publix has a specific policy for inspecting these flower displays and around them. And it requires their employees to not only inspect the floor, but to inspect it for foreign substances. And we know because of their policy that Publix has up to 10 people that are supposed to be in this section doing this. And so we know that we know that they know it's a problem. We know their corporate representative says very specifically that they know that water gets on the floor in that area. They know that their flowers are in these open containers, which are in water. So that's there. And they have zero evidence to say that someone passed through that area and there was nothing there. There is no evidence that says that. And so what we have, and I agree with Judge Kelly, is that when we boil down this case, it was a case of was Publix reasonable in what they did for this flower department? The trial court did not allow the jury to get to that question, which we believe there was evidence there that a jury can make that decision. And all we're asking here is for this court to allow them to do that. So if there's no other questions, Your Honor, we would ask that this court reverse the trial court's judgment.
Thank you, Mr. Lee. Thank you both. That concludes our topic for this morning. We are adjourned.